All right, well, this is part two of understanding the legal system. It's probably a good place to break. We're going to talk about just a court case, how a court case operates. So we've got the trial courts. In Wisconsin, they're known as circuit courts. So every county has a circuit court, and that's generally where cases start. Unless it's an administrative case, then it would start in an administrative court and get bounced to a circuit court if there was an appeal. We always have the right to appeal in our system. That's part of the due process clause I talked about earlier. Due process, what's fair? What's fair is that you have another court review what the lower court did. We've got to have jurisdiction, and I'm not going to get into jurisdiction with you guys. That's a little more than you need to know. Let the lawyers worry about that. And then the service of process I mentioned at the end of the last one. Summons and complaint is really what puts you on notice that you're being sued, and you have to respond to it. Otherwise, the judge will assume that you think you should lose, and will issue a default judgment. So don't do that. I had clients come into my office and say, I got a default judgment, and this case was bogus. And I would say, well, how does the judge know the case is bogus? You got to respond. And then there's a different criminal process as well, which we won't get into either. So the way it starts off, and this is something part of the process that folks should be aware of. We have an answer, a complaint filed. The defendant then files an answer. The complaint basically outlines the reasons for the lawsuit and the facts that support the lawsuit, and then the defendant responds either denying or agreeing with what the facts are laid out. And then the court has a variety of pretrial options. There's motions filed. Sometimes the court will declare judgment before you even have a trial. The trial is really all about resolving factual disagreements. So sometimes you'll end up, both parties agree on what happened, but they have a dispute as to what the law is. Then that case wouldn't even go to trial. The judge would decide who wins or who loses. So a trial is really about having a jury decide the facts. As you might imagine, there's often factual disputes. And so a judge will say, show me the evidence. Is there evidence of these facts? If there's not evidence before a trial, the judge can then grant summary judgment, which means judgment now before a trial. But if there's evidence that shows there's a dispute, then we'll end up letting a jury decide. And a simple example would be, let's say two parties get in a car accident out at a four-way intersection out in the country. They're the only drivers. One person says that person ran the stop sign. The other person says, no, I stopped and they ran the stop sign. Well, we got a disagreement about the facts. It's up to a jury to decide. Not an easy decision, of course. So I don't know what the jury's going to do, but they could look at where the angle of impact, where there were skid marks. In my scenario, there are no witnesses. Maybe someone had a webcam in their car. Okay. That's what trials are all about. Juries deciding what the truth is. Now, of course, juries don't always get it right. Our system is not perfect. The other part before a trial is something called discovery. And during discovery is when the attorneys from both sides have the opportunity to ask questions of the other side before the trial. They can do it in writing, which is an interrogatory. They can do it at a deposition where all the parties get together. They're sworn in under oath. There's a court reporter, and the attorneys ask questions. Some folks think it might take the fun out of the trial, but it actually ends up leading to a lot of settlements because we get the facts before the trial, and then we can find out, whether or not we even need to go to trial, which can be lengthy and expensive. So discovery is an important part. I can ask the other side for documents. I can ask the other side for permission to take photos. I can ask the other side if they have photos that they're going to use at trial, they have to give them to me. It's basically like showing your cards, turning the cards over before the bet or while the betting's going on in a card game. So discovery is an important part of that process. Another part of pretrial, and this, this is not something that you're going to be involved in doing, but you'll be part of it, so it's important for you to understand the terms if you're involved with a lawsuit and an attorney's talking to you. There's motions, and motions are basically requesting that the judge do something. And as we've got up here, you could amend the complaint. You could change the complaint. I could change my answer during the course of before the trial comes. I can question whether or not this is in the right place, whether it's in the right court. And then if the other party won't give me stuff, I can do discovery motions. And so, and have the judge order, I want to see, their tax returns. Well, we can have an argument about whether or not the tax returns are relevant to this particular case. If the judge says they're not, the judge won't give me the tax returns. If the judge says they are, they'll give me the tax returns. And then we get to the trial itself. We basically have back and forth between the attorneys. One attorney makes an opening statement, says what's going to happen. The other attorney comes back and says, no, this is what's going to happen. This is what you're going to hear. And then you present all your evidence. Witnesses, if we have experts, we might have them come in. Documents that we're going to share. I get to cross-examine your witnesses. You get to cross-examine my witnesses. And then we're basically done. There's all sorts of objections. You've probably heard these on TV, hearsay, leading the witness, badgering the witness, irrelevant, and so on. And so you can, try to get evidence denied. Then we end up with closing statements, which is the last argument. End up going to a jury. No, we don't always have to have a jury. Sometimes it can be a judge trial. They call it a bench trial. And then you can ask the judge to direct a verdict, which means this case is so obvious we don't even need a jury. Most of the time, judges let a jury decide it. And then the jury comes back with a verdict. After the trial's over, the case isn't over. There could be motions afterwards. People could argue that the jury's verdict wasn't reasonable, that no reasonable jury could have reached that verdict. They can argue that the judge screwed up during the course of the trial, admitted evidence that shouldn't have been admitted, allowed a witness to testify that shouldn't have been allowed to testify, and then you appeal. So if in our system you always get one appeal. We have a 3-tiered system at both the federal and state level. Your first appeal goes to the Wisconsin Court of Appeals, and then your next appeal would go to the Wisconsin Supreme Court. And so, there's a variety of appeals here. The initial appeal is almost always heard. We have an appeal by right of our appellate court. The discretionary appeals would be at the Supreme Court level. The Supreme Court of Wisconsin and the Supreme Court of the United States do not have to hear a particular appeal. It's up to them. You already got your one due process appeal to the Middle Court of Appeals, and then you appeal to the U.S. Supreme Court or the Wisconsin Supreme Court, and they don't have to hear your appeal. Okay, so I'm going to try to get this uploaded, and then I guess the idea with iFlex is that we kind of run through it, see if you have questions, have some discussion about what we talked about here, and that's what we'll be doing tomorrow. So see you tomorrow.